Sherman case? Okay.
Good morning, Attorney Mills.
Your Honor?
Come on in. Good morning. All right, morning, Attorney Golub.
It is still morning, isn't it?
Yes. All right, we're on the record. This is multiple case numbers. The estate, I call the Sherman estate for shorthand, but there are 4 estates. Nothing had been opened when people would pass until the 4th of these relatives passed, and then we cleaned up an estate and passed it all to the executors, beneficiaries, who were, I'm sorry, Attorney Mills, the names of your clients were William Sherrard and Tiffany Sherrard. They received all the money.
All the money.
Can you put a dollar figure on that for me, quick? Summary, estimate?
From all the estates, or just since we've last been here?
No, just for what the Sherrards are actually reaping out of this whole long story of estate planning.
I don't know that off the top of my head, but I would say in excess of 7 figures between what were in joint or payable and death accounts, properties, and the like.
Is that because you don't have a final account?
I do not have a final account. I can tell you that since we were last here, the reason I didn't have a final account is because I was waiting on unclaimed funds. And I can tell you that those unclaimed funds were paid out. That to Irene Sherman's estate, that was $20,879.78. That the unclaimed funds were paid, and the Sherrards cashed that check on July 14th, 2025. They did not put that in the estate account, and then closed the estate account on July 7th, 25. So before they got the check, obviously. As far as Darlene, the unclaimed funds, the amount was $14,108.46. They received that on the same day, July 14th, 25, and they cashed that check as well. And Darlene's estate account was closed on 7/7/25. They obviously cashed both of those checks, took the money personally, and therefore, from a very long time ago, our fees at $8,555.85 remain unpaid. And that was pursuant to court order of April 2nd.
So they closed the estate accounts without your permission?
Correct.
Without my permission.
Correct. And I have contacted
And they
them.
cashed checks outside of the estate.
I have contacted them on numerous occasions. I have not gotten any type of response. I actually had Cube Mart or some storage facility track me down to contact me. They had not paid the storage unit. The storage unit woman had indicated that she was having a difficult time in getting into contact with them as well, which is why she tracked me down. So as far as we requested a status conference just relative to the facts that I just described, and then we prepared a proposed order that they return the unclaimed funds that they cashed personally, and that they do so by November 30th, 2025, provide evidence the same to avoid contempt and further orders of the court, because then once I have this court order that they should return it, then I would file a contempt in order for them personally to be liable for those sums. I don't know any other way to do it.
I hear you. And you're probably on track, right? I mean, the court's already approved your fee.
Yes.
So the fiduciary has to pay that fee in order to close the estate, as well as sign a final account. Although the court has done in the past and is willing to do so given what you've just reported, issued an order authorizing the attorney to sign on behalf of the fiduciary any final account necessary to close the file. But obviously this case seems to be a story of ignoring the authority of the court and just taking what we think we want and walking on. I don't know where they went that, but the Sherrards, they live in Carrollton area. No one's been able to find them.
No one's been able to find them. Carroll County, I do think, was the last time. Storage lady thought perhaps the two had separated. I mean, I have no idea, but we have called numerous times, cell phone, and received.
So you're asking me today to issue an order compelling them to stand before me and answer for these charges. And then if they fail to appear there, then we can use the powers of contempt.
Yes.
And to return the funds and reopen an estate account, which they weren't to close until they had a final account approved.
Yeah, we'd have to reopen.
And which meant they paid you before they got their final account approved.
Correct.
And ultimately, if they never show up, my thought is we'd somehow get into your hands a judgment entry for your fees so you can use alternative collection methods to try and get paid. You deserve your fees. It says, I don't know, four estates.
We stopped accounting for any additional fees probably since April 2nd.
And they're $8,000 and you closed 4 estates.
Yes.
Which weren't being done. When no action was being done. Money was going left out the door, but nothing was getting done, and you came in and it got done, save for a final account, and now your own clients are working against that endeavor. So whatever you got, we'll go forward to get it done. We were hoping they'd show today and we'd resolve this.
Was hoping.
They're not unsophisticated because they've had to ride these 4 states through 2 council. So I think you know better. But we'll give them the benefit of the doubt if they would show and talk to me. And we could wrap it up. Quite frankly, they're entitled to all the money. It's just pay your attorney and sign the final account.
Exactly, it would be done.
Yeah. All right, anything further for today?
No, thank you, Your Honor.
We'll issue you have a proposed order. I'll review it and most likely issue as proposed, which the purpose is to order them to appear and answer for these monies.
I have the amounts in here. I do not have that they should appear, so I can certainly revise that, Your Honor, and have it brought back over. So however since we didn't file a motion, then for the contempt, we filed for the status requesting they return the funds. I certainly, I can revise it to have another court hearing.
Let me take a look. I can come up with one.
Okay.
I'll call if you need something. All right, that concludes our hearing.
If it pleases the court.
It does not.
It doesn't please the court?
What do you have to say today? Have you met the Sherrards? Are you bringing them with you? Do you represent them?
No and no. I did file a motion for the fees, but also I would add to what opposing counsel has indicated.
Why? I've heard what opposing counsel wants me to know.
Well,
you're not counsel for this estate. I'm trying to close the estate with a final account. My only questions and my only purpose for the status hearing are where is my final account and why isn't this estate closed? I have heard satisfactory argument that the reason the estate's not closed is because the Sherrards are not cooperating. If you have evidence that the Sherrards can be found, then you can present that.
we filed the motion for fees.
It's under advisement. It's not the hearing today. It was not set for today.
They told us it was.
Who told you? Who was they?
Tim Jeffries.
We contacted before.
They told us it was set for a hearing, so we prepared for the hearing.
Fair enough. It is not set on your fee motion.
Okay, let me present this. On the final estate, I just filed a hearing exhibit.
All right, we haven't filed yet. We just want to show it to the court.
I want to show this to the court right now.
I'll take it.
Thank you.
Okay, court will receive it in. File. I guess we'll file stamp it.
You know, just so I can explain this, because the other counsel said that's $102,000, which we informed Ms. Miller of when this case started, and that's not been made account for. We see that the Sherrards have gone after money without her knowledge, and that could be another $102,000 that they received in this estate, which should be made an accounting for, which we did notify her for when this case, when she first took over the case. So there's $102,000 additional.
All right. Sounds like you'd be prepared to file an exception or an objection to the final count, which is not filed, and I don't even know if you'd have standing to object to the final count, but I'll take your evidence in.
Wouldn't hurt.
Correct. All right. Thank you all.
And are we going to have this hearing set on this motion?